everyone. Hello, good afternoon. My name is Robert Rosenberg, and I am here this afternoon with four of my extremely well-groomed colleagues. We have all brushed our hair ready for the event. And we're here to talk to you about the Bank of Mum and Dad and what happens when you have some spare cash and you want to give it to your favorite child or all of them. And what method would you use? Obviously, you can just transfer them some cash, but a lot of people like to transfer it to a solicitor in order that they can buy property. And what we're going to do is we're going to take you through the various types of ways of doing this, from the one with the most control to the one with the least control. And we'll talk about all the stuff in between. So I'm going to introduce everybody. First off, my partner in property, head of property, Michael Stock, is joining us today. We also have my colleague, Ben Menahem, who is an associate in our property department. We will be passing to my colleague, Jamie Romer, a senior associate in our private client department, so he can tell you about estate planning and taxes and things like that. And also we are joined by my partner in family, Graeme Fraser, who will tell you about all the different angles on the on boyfriends, girlfriends, and all the other things that you can have nowadays. Okay, so I would first of all like to pass over to my partner, Michael Stock, to say hello.
Well, thanks, Robert, and thank you everyone for making the time to join us today on this brief whistle-tour stop of this very important subject and topical. Well, I'm Michael Stock and I'm head of OGR Stock Denton's property department. The Bank of Mum and Dad is obviously the topical tabloid name, but it can apply to anyone who wants to help a young couple, grandpa and grandma, uncles and aunt, family, relatives and friends. So that's the colloquial expression we'll be using today, mum and dad, and then we're going to refer to mum and dad throughout. But just remember, it can apply to that any category of person, any type of person. And they may, and as I said, they may want to help a young couple usually starting on the property ladder. And the point that I want to make here is that the giver, the donor, if it is going to be a gift, and we'll talk about the various options later, wants to normally see the young couple enjoy the gift whilst that giver is alive. You know, many is the time where a person makes a gift, but they're dead and they don't see the young couple enjoy the gift. So we've got this juxtaposition of, do you make a gift? Do you not make a gift? Is it to be a loan? So we're going to explore some of these options. And the point that I want to make at this juncture is, do mum and dad really want to make a gift? As we'll see, this sort of topic brings into play the various specialist skills of my firm. Of course, it involves property advice initially, but you'll see it's absolutely imperative to obtain advice from my firm's other specialist solicitors, of family law, Graeme, and wills, trusts and estate planning, Jamie, and of course, Ben, my property solicitor, associate solicitor colleague, will be speaking in a few moments. So everybody, I'd like to paint the scene for everybody. So we got this typical scenario. Bonnie and Clyde are two lovebirds, not yet married. They want to buy a flat for £600,000. And Bonnie says to her parents, normally Dad, I'd like to buy this property with Clyde. Can you help? So as I indicated in my introduction, this brings into play a number of problems. On a firm solicitor aspect here, who are we advising? Who is the firm of solicitors advising at this juncture? It's usually mum and dad, who are extremely concerned about Bonnie's romance with Clyde. And of course, Dad doesn't trust Clyde in my example. Indeed, I receive a fair number of calls from Dad in that situation, who says, look, I asked Clyde what he does for a living, and he says a bit of that, bit of sales. In other words, he does absolutely nothing. So he says, Michael, we've been burnt once. We made a gift of £400,000 to our eldest daughter, Chloe, 2-3 years ago, and she divorced 6 months later. And we don't want to be burnt again. What do you advise? So the point that I want to stress here is what we as solicitors are looking at is to advise mum and dad on the control mechanisms. It's all about the level of control that mum and dad want to exert here, ranging from no control with an absolute gift, ranging to absolutely putting a firm lever of control on perhaps making a loan. So without further ado, we'll explore these options, and I'd like to invite and introduce my colleague, Associate Solicitor, Property Lawyer Ben Menahem, to go through the options available. Ben, over to you.
Thanks very much, Michael, and welcome everyone. Thanks for taking some time out of your lunch break to be with us. So to jump right in, as Michael said, mum and dad, you have 4 options. And what we're going to do is go through each option and see from a property, family and private client law perspective, the best way to approach this. And in each option really is the level of control you guys, mum and dad, would have against the amount of tax you'd be liable to pay, and also perhaps the stress you'd feel, and maybe you can balance up those options. So jumping into option 1. So here's where you have the most control, but arguably the most hassle. This is where mum and dad buy the property in their own name. So this is an additional property to the one you live in. And the good things is that you can do as you please. You can design, develop, carve up, sublet. No one else can deal or go to the bank and take a loan out against it without your knowledge. And the property will go to your children anyway in your will, you may think. But one thing to bear in mind, which Jamie will elaborate on, is as a purchaser, you'll be on the hook for all the taxes that come with that. So as you know, topical tomorrow we'll find out, stamp duty, land tax, at the time of purchase, you'd have to pay that. And in practice, our clients are quite hesitant about this way of helping their kids. The idea is to help, not necessarily to repair and manage a property. And sometimes it's all too much like hard work for mum and dad. So with this in mind, we're going to turn firstly to Jamie, and Jamie can help you understand sort of the tax implications. And then we'll go to Head of Family, Graeme, to look at family considerations. So Jamie, if mum and dad want to buy in their own name, good idea?
Thanks, Ben. Okay, so if mum and dad purchase the property in their own names, it's great from a control point of view. They retain full control of the property. But from a tax point of view, it's really not great at all. And there's also one other practical aspect that I'll go into afterwards. Firstly, turning to the tax points, capital gains tax is going to be an issue. So just to very briefly explain, I'm sure people are mostly aware, but just to briefly explain, if I sell the property that I live in, I don't have to pay capital gains tax on the gain between the date that I purchased it and the day that I'm selling it. The reason why I don't have to is because there's a relief. It's called principal private residence relief. Because it's my main residence, I'm exempt from capital gains tax. That only applies, of course, to the first property, or the property that I live in. If I own more than one property, capital gains tax will be applicable to those other properties. So in this case, mum and dad obviously live in their own home. They'd be purchasing this as an additional home for Bonnie and Clyde to live in. And therefore, it will be in the net for capital gains tax. So that's the first thing that they have to consider. If it's decided that Bonnie and Clyde are going to move somewhere else at a later date, when that home is sold, there will be capital gains tax. That's the first tax to be aware of. The other tax, of course, is inheritance tax. Because mum and dad own this property, it's going to be in their estates for inheritance tax purposes. So although it's not their property for intent purposes, because Bonnie and Clyde are living there, they don't have the benefit of the property, it's still completely and totally in their estate for inheritance tax purposes. And you might come into a situation where mum and dad, you know, God forbid, one of them, both of them, let's say, pass away at some point. There's going to be a big inheritance tax bill, but the property is actually being lived in by Bonnie and Clyde. It's not going to be sold, and that could cause difficulties within the family down the line. So those are the two tax issues that mum and dad have to be aware of if they go down this route. The practical issue that I want mum and dad to be aware of in this option is they may very well have prepared wills where they leave on second death all of their estates equally to all their children. So let's assume that Bonnie has siblings. In that case, Bonnie's home, the home that she's living in with Clyde, could eventually belong equally to her and all her siblings, which is not a great situation to lead the family. It's not a great road to lead the family down. So mum and dad, if they go down this route, will want to be reviewing their wills to make sure that they can restructure them in such a way as to not lumber their children with this. So that's really the perspective, from my perspective, on this. Now over to Graeme to view it from the family perspective.
Thanks, Jamie, for that. In terms of the children, their claims are going to be, well, their rights are going to be very limited if the property is in Bonnie's parents' names. And the only way that something could be established is by establishing a beneficial interest through constructive trust, which is a difficult thing to do, but also stressful if there are arguments about that at a later stage, either where the couple are living together or if they get married in the future. The other thing that they could do is that they could enter into a cohabitation agreement whereby they deal with matters such as the payment of living expenses and improvements and things like that. But the question I would raise is what would be the incentive for Clyde to enter into that agreement under this level of control? So my concern is the level of stress and control that would derive from such an arrangement, and would it actually be something that would be depriving the children from something that they actually living their lives, which I think was referred to in the introduction. So back to Ben for the next option.
Thanks, Graeme and Jamie. Very helpful as mum and dad sat there, maybe even the kids, balancing up control, tax, and stress. So now, if you join me with the very last option, so all the way to the other end of the spectrum, from a situation where mum and dad buy the property in their own name to now the lease control. And this is where mum and dad make an outright gift of the money so the kids can buy the property. And here is arguably the most stress as well. So lease control, but most stress. They're not expecting any repayment, and they're not expecting any interest in the property here. So watch out, mum and dad. Effectively, you'd be signing a declaration, which I, as your property lawyer, would ask you for on my file, that you'll have no interest in the property. Obviously, you'll be clients of the firm and we'll look at the source of funds for this gift, but those are details for another time. And interestingly, even though Bonnie and Clyde have to buy the property, there's no telling what they can do with the property, and you have, no control. They could sublet part or whole of it, maybe take a trip to the Bahamas, refinance and run away with the money. God knows what they can spend this on. And our clients here, when faced with this option, are quite skeptical because they're essentially kissing the money away. And perhaps without the proper infrastructure in place, which is what we're here today to tell you about, it could be a recipe for disaster as between the kids if things go wrong between Bonnie and Clyde. So just to wrap up, whilst the lovely gesture to give the money to Bonnie and Clyde, that type of gift does need assessing, especially with Jamie and Graeme at the outset. And before going to Jamie for some more tax implications of the gift, Graeme helpfully can shed some light on Bonnie and Clyde's setup, whether they're getting married, perhaps if they get divorced, God forbid. Graeme, over to you on the gift from mum and dad.
Well, probably that's going from one extreme to the other, because that's the least amount of control in terms of what happens to that money. Essentially, Clyde would say, well, that's his entitlement, and the parents have no control what happens afterwards. If the relationship doesn't work out, in particular, there could be a lot of bad feeling about it. Probably longer down the line, if they get married, this is where a lot of the arguments take place in terms of, was that a gift, an outright gift? Was it a loan? Was it only given to Bonnie? So it's a recipe really for ill will and hostility in the future, unless that's genuinely what they want to do. So it's the loss of control that's a concern. In this situation where they're still cohabiting, we would always recommend cohabitation agreement. And the other thing that can be done if they're planning to get married is that they have a prenuptial agreement, and this is referred to as separate property because it derives from Bonnie's family. But it is a situation really where the horse is bolted, and the way the parents have control of that money is deciding what to do before they actually release the money. Thank you. I think over to Jamie now.
Thanks, Graeme. Yes, so if mum and dad have decided that they trust Bonnie and Clyde enough to give them the money to buy the property, obviously, as we've mentioned, they've lost control. If they've decided to go down that route, from a tax point of view, it's pretty good. Obviously, there won't be any capital gains tax issues here because mum and dad do not own the property and they've not gifted an asset which is liable to capital gains tax. They've gifted cash, of course, doesn't come under the capital gains tax regime. So from a capital gains tax point of view, there won't be any issues here. That's good. From an inheritance tax point of view, it hopefully will be a good thing. Obviously, there's two caveats here. One's more obvious than the other. The obvious one is it's a pet, a potentially exempt transfer. So mum and dad have to survive 7 years from the date of the gift for it to have fallen out of their estate for inheritance tax purposes. If they do survive that 7 years, it should be out of mum and dad's estate. So there's actually been quite a good bit of tax planning for them. But of course, they do have to survive 7 years. And if they don't survive 7 years, then as I said in the previous option, Bonnie could be lumbered with, or Bonnie and Clyde really in this example, could be lumbered with a hefty inheritance tax bill on this gift, and potentially not have the liquid assets to pay it because this might be their main asset. They might not have their liquidity, so that would put them in a difficult situation. It is possible to take out insurance when you've made a gift, and that's something that might be worth looking into, but not really the subject of today's talk. So that's the potential, the one caveat that they have to survive 7 years. There is another one which might not be as widely known and potentially might not be so relevant, but it's definitely worth mentioning. If we're going down this route that mum and dad trust Bonnie and Clyde so much that they're happy to give them money to purchase the property, it could be that they feel very close. And there might be a tendency for mum and dad to say, well, we've given you the money for the property, we're very close, we'll come and stay with you. You've got to be very careful because there are limits to how often one can stay in a property that one has fronted the money for in terms of it leaving your estate for inheritance tax purposes. If mum and dad go and occupy that property too often in any given year, it could be that it's caught back into their estate as a gift with reservation of benefit. So care just needs to be taken that mum and dad don't overstep the limits there. But if these two caveats don't materialize, if they survive 7 years, if they don't overly occupy the property, then it will leave their estate for inheritance tax purposes, and potentially there'll be no capital gains tax, there'll be no inheritance tax. It'll be a good bit of tax planning. Over to you, Ben. What other options are there for mum and dad?
Thanks very much, Graeme and Jamie. Again, Jamie, just making sure when you said pet, you're not describing Clyde's utterances to Bonnie. Okay, very good. We've had both extremes, but I can see everyone thinking there's got to be a middle ground. I don't want to buy it in my own name, mum and dad. I don't want to give the money to the kids. So good news, there is a middle ground. So this option is where mum and dad can still help Bonnie and Clyde pay some tax and maybe mitigate their stress as well, which is welcome in these times. And this is when they loan the money to Bonnie and Clyde. This is an interesting and often preferred option for our clients, but it does need to be assessed at the outset with all our departments and set up correctly. Otherwise, it could end up horribly wrong. And that's what we're really trying to avoid here, is the worst case scenario, which all too often can happen in these family setups. So here, Bonnie gets her flat, so does Clyde maybe, and mum and dad get a registered legal charge over the property. So on the registered title deeds, mum and dad's name would appear there, and seemingly a win-win situation. And the beauty of this option is if it does all go wrong, mum and dad can step in, sell the property and get their money back. But here are the key considerations. What are the terms of the loan? We don't have nice Barclays to provide us with standard loan terms on this one. When would it be repaid? Should mum and dad charge Bonnie or Clyde interest? Surely not, I hear you cry. Are Bonnie and Clyde both and each of them liable for the full amount of the loan? Can one law firm, OGR Stockdenton, act for all the parties in this type of setup? Perhaps. What if one of the parties got hit by a bus or struck with COVID-19? Or if they're really unlucky in this hypothetical situation, both? These are the type of things that we would consider for the parties and direct them to the best people. The main point with this option is that Bonnie and Clyde, even though they get to live in the property, their dealing with the property is somewhat restricted, and they can't sublet, even alter, and certainly not go to the bank and raise money without going to mum and dad first. And this really does give our clients, mum and dad in this case, a real peace of mind. And one sort of acute point is that Clyde, in our example, could turn around and say, hang on a second, this isn't a real loan, this is a soft loan. And if you want to call it back, I'll argue under the Consumer Credit Act that it's unenforceable and onerous. And indeed, we have seen this argued before. So these are the type of situations we try to prevent by considering it early on. And this is in particular helpful to have Jamie, who will talk a little bit more about tax implications when mum and dad loan. But before then, Graeme, what do you think about this option from mum and dad?
Well, it's more desirable in the sense of than the last one because there's a greater level of control. But would it be necessarily my preferred option? I would say that where the couple is unmarried, the best thing to do to protect the beneficial interest is to have a declaration of trust drawn up, and for the parents to have their they're called third-party interests. They can be registered. They can be included in that by noting their contributions. That will certainly ought to be definitive in a situation where the couple are unmarried. With reference to soft loans, that's a common point that arises on a divorce. There are often arguments to and fro between the parties and their families about what was it? Was it a gift? Does it really have to be paid back? When does it have to be paid back? My view about that, and I'll defer to other lawyers about the commercial terms, is that you need to get into those arrangements at the time of the gift. Don't try and do it later on. Don't do it on the cusp of when the relationship is breaking down, if that's what happens, because then that really does look as though that's been manufactured. So in my view, do something very clear, do it in writing, and make sure that everybody gets independent legal advice on the documents. That would be my advice. But I think the way to go, in my view, from a family perspective, where the couple are unmarried, contributions, is to have a declaration of trust. That would also be coupled with a cohabitation agreement where the couple are living together and are unmarried. On to Jamie now.
Thanks, Graeme. From a private client perspective, I would say this option is the worst of both worlds. I mean, okay, you don't have capital gains tax because mum and dad don't own the property. So again, like we said in the previous example, it's not part of the capital gains tax regime. But for inheritance tax purposes, it's still very much in mum and dad's estate because they have the benefit of the loan. The loan is due to mum and dad, and therefore there's no 7-year clock running or anything like that. It just remains as part of mum and dad's estate. So from that point of view, it's not great because they don't have full control over the property. You know, they do have the benefit of a charge perhaps on the property, but they don't have, they're not holding the legal title. So, you know, they've got very little control over the property itself, but the full value of it is in their estate. So it's really not great. I mean, it is possible for mum and dad to, and we'll talk about this a little bit later in greater detail, it is possible for mum and dad to gradually reduce the value of the loan. But if there is a mortgage on here, another mortgage, it could complicate things in terms of stamp duty, land tax at the end when mum and dad want to pull out completely. So that's just something else to be aware of. There's something else that's really a side point for this particular topic that you've mentioned, Ben, but I think it's just so important that I've got to raise it now. When you mentioned, you know, what if you go under a bus or get COVID or both? That's really an issue that is relevant to all of us, you know, not just to mum and dad, not just to Bonnie and Clyde, not just purchasing a home. You know, we all have assets, we all own properties, we all have bank accounts, we all perhaps have investments, holding shares, etc. You know, we've got to be sure what's going to happen to our assets should we still be alive, but no longer have the mental faculties, mental capacity to manage our own affairs. And the way to deal with that is to enter into a lasting power of attorney, whereby you appoint an attorney who will be in a position to manage your affairs should you no longer be able to do. It's such an important issue that we all should be thinking about, aside from this topic. So thank you for mentioning that, Ben.
Thanks very much, Jamie, and Graeme too. And I'm sure everyone's finding this is really helpful to have big picture thinking here for our clients, and not just the tunnel vision that maybe some people enter purchases and gifts into. And just to add to, you know, what Jamie was saying about that potential option, is that mum and dad do have the ability to reduce the amount of the loan and therefore their tax liability. So we've had 3 options: mum and dad buying in their names, loaning the money, gifting the money, anything else. You know, your lunch is nearly over and you want to know if there's any other options. Yes, there is. And this is actually an option that our clients do like. This is the joint purchase. This is where mum and dad buy with Bonnie and Clyde. Interestingly, four names can appear on a registered title deed. So in our example, this would work. And this is a good option. This gives good control for mum and dad. They almost have one hand on the trophy. Flexibility with taxation, which I'll allude to and Jamie will expand on. And the key point here is that if something does go wrong between the kids, mum and dad can step in and deal, you know, with less bureaucracy. So by having mum or dad with Bonnie and Clyde on the title, they could choose the percentages that they buy in. So for example, mum and dad at the outset could have 60% and give Bonnie 40%, or Bonnie and Clyde 20% each. And if after a long conversation with Jamie, mum and dad want to reduce their tax liability, then I can draft a document to change these percentages to mum and dad only having 1% and Bonnie and Clyde the 99%. So this is quite a nifty trick with this option. And the beauty of working with the likes of Jamie and Graeme in differing departments is that we can plan ahead for the clients and see things years down the line rather than just dealing with the particular matter at hand. So on this, Jamie first, and then we'll go to Graeme. Can mum and dad buy with the kids from your areas?
Thanks, Ben. Yes, from a private client perspective, I think that this is probably a good middle ground compromise. Trying to find that balance between retaining some element of control, but reducing the potential tax liabilities as much as possible. So if mum and dad do own part of the property, they obviously are going to be back in the capital gains tax regime on the value that they own. But they do retain some element of control over the property because, you know, their names are going to be on the legal title. So that will definitely give mum and dad the comfort that they need. From a capital gains tax perspective, as I said, they will be in the capital gains tax regime, but unlike the first example that we had, the whole value of the property will not be subject to capital gains tax, only the value that mum and dad own. So let's say mum and dad and Bonnie and Clyde, they go 50-50. So only 50% is going to be subject to capital gains tax, not full value. So you've already cut that in half. From an estate tax planning, inheritance tax planning point of view, it's also better than the first example because the whole value of the property is not in their estate. Only half the value of the property. And in actual fact, the entire half value of the property is not going to be in their estate for inheritance tax purposes. Because when you own a property with someone other than your spouse, you have a joint ownership with someone other than your spouse, there is a 10 to 15% discount when it comes to actually filing the inheritance tax papers on that value. So in our example, if the value of the flat is 600,000 and mum and dad are going to own 300,000, so it's 150,000 pound each, they won't actually, the value of their share won't be 150,000. It'll only be either 90% or 85% of 150,000 pounds. So the inheritance tax implications are quite reduced. Now, what Ben alluded to before, and what I also briefly mentioned in the previous option, is that as time goes on and mum and dad decide that they trust Bonnie and Clyde more, or they feel closer with them, they want to set them up on their own 2 feet even more, they can gradually reduce the share of their ownership. They have to take great care over here not to give more than the annual exemption for capital gains tax purposes, because as I said, their share of the property is caught by the capital gains tax regime. And if they give to Bonnie and Clyde more than the amount of the annual exemption, it will trigger an immediate capital gains tax liability. So they obviously don't want to do that. But if they do it carefully, with careful planning and advice, gradually, annually in small increments, reduce their holding of the property up to the limit of the capital gains tax annual exemption, they can gradually reduce that and pass over to Bonnie and Clyde. And that will obviously reduce the value of their estate further as they go along. Obviously, as I've mentioned before, they need to survive 7 years from each gift. So it will take 7 years for those gradual gifts to actually leave their estate, but it's certainly something that can be done. Graeme, how does this option look from your perspective?
Well, if we're looking on the side of the unmarried couple, it's quite a positive option. Everybody knows where they stand. Everything can be recorded, and it can be done through a declaration of trust. And you can also have a mechanism in the cohabitation agreement that facilitates the increased share of the children. So it's quite a nice option from that perspective. My only concern about this is when the couple have children, and ensuring that they have a home where their children can live in a situation where the parents still have are still part owners of that property. So that's a concern. And in particular, we do see some complexity arising in a divorce situation if this couple go on to marry, and then the issue of what actually is a matrimonial asset, because essentially the part of the property in the parents' name would be excluded, and then there becomes a pressure in terms of meeting needs. So I think it's something that needs to be looked at and carefully reviewed as the couple go through life. But in terms of the examples given, it's one of the best. And I think back to Ben.
Thanks very much, Graeme, and Jamie again. We've had all the options now from 1 to 4, and back to Robert to summarise and maybe take some of your questions.
Okay, thank you, guys. So we've actually finished, pretty early. It shows that we don't just talk and talk and talk. So what I'd like to do now is use the remaining time to take some questions. If you wouldn't mind sending them to me on the chat, that would be great. I know a couple of people have got hands up, but if you send them to me on the chat, then I can ask the correct person. Don't worry, I won't give your name away. You know, so your secret will be safe with me. One's already arrived here. It's for Graeme. How does the advice change if the couple are going to get married in the next year or so?
Yeah, that's a very topical question, Robert, for two reasons. Firstly, because we believe that weddings are going to become a lot more popular at the end of the pandemic, because there was a period where getting married was actually illegal. And secondly, the Law Commission are currently reviewing the wedding laws to make weddings easier. So I do believe there will be more weddings. I think what's very, very important to get a grasp of is that a cohabitation agreement and a declaration of trust in themselves will not protect Bonnie or her parents in the event of divorce. The only way to protect that is by having a prenuptial agreement and by defining marital and separate property. 6 months from the wedding is a very good time to negotiate these agreements. They must be entered into freely and voluntarily, and it's a good idea to try and get closure on them at least 3 months before the wedding, not only because this is in accordance with Law Commission recommendations, but it also allows the couple the opportunity to focus on their wedding plans free of these stresses. So the strong advice is go and get a prenuptial agreement at that time. Back to you, Rob.
Okay, so we do have another question. What about buying via a trust? Now, we have discussed declarations of trust, but I mean, Jamie, could there be, as the trusts guy, are there any other ways of doing it, or is it just the declarations of trust that we've been talking about?
It certainly is possible to buy a trust. It complicates the matter much more because certainly from next year, I don't know whether people are even aware of this, but from next year, every single trust, whether it's taxable or not, is going to have to be registered with HMRC. And there's a whole lot of administrative things to go through on that. So that's just number one. It's going to be an administrative nightmare. It's going to need to be registered with HMRC and go through all of that malarkey. So that's number one. It obviously needs to be kept below the nil rate bands to make sure that there's no immediate trigger for inheritance tax. You don't want it to become a lifetime chargeable transfer. But it's an option. It's worth considering, but it is much more complicated, and we didn't really want to focus on that in the time that we have. But it's an option, and it needs to be obviously looked at in the circumstances of the family. Okay,
and another question, because you mentioned this, what's classed as overstaying? You're welcome. When the property's in the kid's name, but the parents stay over. I mean, don't get me wrong. I love having my mother-in-law and father-in-law come to stay with us, but you know, what's overstaying is a you know, obviously I'm assuming it's difficult to answer, but is it a week, 2 weeks? You know,
it's not a week or 2 weeks. It's a difficult question to answer. It's quite technical, but you're looking at more like a few months rather than a few weeks. So I think you'll be all right, Robert.
Great. Okay, so there's a question for maybe the property people. What's the position where both Bonnie and Clyde put in unequal amounts of money, or only one of them puts in money, and mum and dad make a loan as a second charge? So this is a situation, you know, being blunt, you know, one family is wealthier than the other, and you know, they put in more money. What Michael, what
I mean, I'll come on to that. I just want, there's a question that's coming on the annual exemptions for capital gains tax, which I think is about £12,900 per spouse or per civil partner. So again, this time of year, you would look at possibly making gifts before the end of this tax year, and then make another gift if we're going to go down the hybrid option. So I just wanted to mention that. Also on the hybrid option, I'll come on to the question quickly. Don't forget about, when I say the hybrid option, it's joint purchase with Bonnie and Clyde. That does have terribly emotive and psychological problems. It does mean parents exerting control. And also there will be stamp duty land tax consequences on that at surcharge rates. So that needs to be factored in. On the question in hand, where we have Bonnie and Clyde, often that's the scenario. Bonnie and Clyde, unequal contributions. Normally one will provide a lot more, actually. Then you are into the territory of declarations of trust for the young couple. And then if they're getting a loan on top of that from one of the, let's say, Barclays or whatever, then you've got to, and the parents may want to make a loan, you will need the consent of that first lender, which is not necessarily forthcoming. So the parents may not be able to help out in that. Mum and dad may not be able to help out in that example. Also, Graham's point about a cohabitation agreement side by side with the declaration of trust, setting out the unequal contributions, losses, profits, capital gains, etc., and their rights and duties to each other, the couple. One point I'd also like to make there is, don't forget about life insurance, life assurance. That is, that as a young couple, and hopefully they'll be very healthy, they can get that at a low rate, so that God forbid if anything did happen to one of them, then they can write it in trust for each other. I don't want to get too technical, but life assurance is often forgotten there, where they are getting a first mortgage from Barclays or whoever. But in that scenario, it's going to be more difficult for mum and dad to help if they're going to get a first mortgage. I say more difficult, it's normally with a cash help. The second charge behind the first lender is going to be more difficult. So I hope that gives a snapshot of what goes on.
Thank you, Michael. So if anybody else wants to ask any more questions, they can. If not, I would like to thank all my panelists here today for educating us. I think what we've shown is that there are at least 4 ways of mum and dad giving gifts and properties over to their children. What is right for you is obviously a matter of discussion, because you've got different kids, and we can talk to you. And what is important, of course, in all of this is that when you're thinking about gifting properties and gifts to your children, you've got to think about lots of different legal issues. You can't just speak to a property lawyer who will just simply transfer it and do what they say. You've really got to think about all the issues, because people are going to get into relationships, and people will die. And you need to really think very carefully about all the tax consequences and family consequences and property consequences that these gifts are going to make. Okay, so thank you very much, panelists, again. I hope you have a wonderful afternoon, ladies and gentlemen, mum and dad, and thank you very much for joining us.